Good afternoon, everybody. Welcome back to Stewarts Soundbites. I'm going to wait just a couple of minutes. Well, not a couple of minutes. We don't have that much time, Ben. We've literally got 15 minutes. So we'll wait a little bit just to, whilst people are kind of filtering in. And I've just realised that it looks a bit like I'm wearing pajamas today, but I promise I'm not. I promise.
That's what everybody says.
Yeah, well, I definitely do. I mean, I don't profess to be very smartly dressed, but I'm not wearing pajamas. So yeah, but so today we've got a treat for me and for all of you, actually, because we've got Ben Townsend today, who doesn't need any introduction, but to be polite, I'm going to do it anyway. Ben is a partner at Stewarts in the Leeds office and works, as we all do, on catastrophic injury cases. Ben is an expert in spinal cord injury cases and brain injury cases, and a whole lot of other high-level injuries. And we're going to talk today about stress. We are all stressed to a degree, but sometimes, and I know we've talked about this before, Ben, because Ben and I work really closely together, we sometimes forget how stressful litigation is for clients, and we sometimes feel that we are bearing the brunt of it all for our clients, and that includes members of the MDT, and that we're bearing the brunt of the litigation process, and they are focused on their rehab. And oftentimes clients become so stressed about the litigation for lots of different reasons, and we just thought it was important today to remind ourselves of that, and to have some insight from Ben as to kind of what causes the stress in litigation and how we can deal with that. So I think I've waited on enough for everyone to come in, Ben. So I want to start off kind of naturally, I suppose, by talking about the early stages of cases. Early doors is obviously an extremely stressful time for a claimant who has sustained a catastrophic injury, but maybe you could just elaborate a little bit about why those early stages particularly are so stressful.
Yeah, I mean, the early stages, I mean, everybody's stressed all the time in the modern world, but on top of that, claimants who've been catastrophically injured, they've got an injury that they're getting used to, they're worried about work, they're worried about money, they may be very worried about the relationships around them, how stable those are, what's going to be happening to them. And on top of that, they've got the litigation, which is hopefully going to result in them getting some compensation to try and help them put their lives back together. So there's an awful lot going on for them, and it's we should never ever lose track of that. And for me, key to helping clients to deal with that is having a plan for the litigation, showing them that there is a track to take them towards an end goal, rather than just saying it's going to be years and we'll let you know when we're getting close. There's got to be a plan in place for them to get them there, and that applies both for the lawyer with the litigation and of course for the rehabilitation as well, for the case manager.
Yeah, and I find as well, but I know in our cases, you know, when you have an immediate needs assessment, for instance, sometimes that in and of itself can be quite reassuring, can't it? Because there's kind of a tangible plan towards getting better,
yeah,
which is always good. And another thing that causes a lot of anxiety, a huge amount of anxiety, in the relatively early stages is when we have a case where there are criminal proceedings going on. So I wanted to talk a little bit about that, and sometimes there's a bit of confusion with our clients between the criminal proceedings and the civil proceedings and how they are separate. And I suppose how do we go about supporting our clients during criminal proceedings when they're running alongside the compensation claim?
Yeah, I mean, it's easy for us lawyers to forget that people don't appreciate there is a distinction between the criminal and the what we call the civil compensation claims process. It's easy for people to think that those must be the same thing going on at the same time, and they are entirely separate processes. And unlike the claims process that you and I are involved in helping clients with, the criminal process isn't run by them. They don't make the key decisions on it, and they may feel quite stressed by that, the lack of control and the delays, especially at the moment, that there are in the criminal process. So that can be very disempowering, make people feel really stressed by the lack of control that they might have with that. And it's about trying to manage their expectations with that criminal process, where it's going to go, what the likely or potential outcomes could be from that process, which for many people ultimately may be very disappointing, but that's a process that they just can't control.
Yeah, and I suppose making it clear as well, Ben, that kind of our side of things, so the civil claim isn't about punishing a defendant, really, you know, a driver or whoever may be prosecuted.
Yeah, it's not about retribution, and
yeah,
people need to appreciate that, both in the criminal side of things and the civil side.
Yeah. And what about, so we've covered early stages and the criminal process. What about kind of the other key stages then of the litigation process that are particularly stressful?
Well, expert appointments, I think, a key point of stress for people.
Yeah.
Many of our clients are going to have life-changing injuries with perhaps potentially embarrassing symptoms involved with that, certainly very difficult symptoms to potentially talk about. And they're going to have to be talking about that to both to the lawyers, to the rehabilitation providers, to the treating doctors, but also the experts in the case as well. And these are people who aren't there to treat them, aren't there to make them better. And they might have to talk to them, having never met them before, and potentially never going to meet them again, about being incontinent or impotent. And those are difficult things. It's also stressful because they know that these appointments are important, that this is important evidence in the case. So they will be aware that it's what happens and what they say about themselves in these appointments is going to make a difference to their case. So that is difficult enough in itself, but added to that, there may be a difference in the way that experts are with them, and defendants experts may be rather more hostile than their own experts on their own side, sadly.
Yeah. And it's always horrible to receive a call, isn't it, saying that somebody's had a bad experience with an expert, and you feel somewhat responsible, but you know that's kind of out of our control. And just leading on from that, actually, it leads nicely on to what I was going to ask you next, which is about how most of our clients, well, all of our clients preferably, should be supported at those expert appointments. And oftentimes it's a case manager or a rehab professional, a support worker, with somebody during those expert appointments. What can those people do in preparing for and attending those appointments? What can they do to manage stress and kind of provide support?
Well, you're absolutely right, Em, that people do need support with these appointments, whether it's from a family member or from a case manager, because our clients will often be vulnerable, and they will need support during this process. And it's about preparing them for what's going to be happening, talking through the sort of things that they're going to be asked, preparing them for having those conversations, so that when they're asked about, say, their incontinence, that doesn't come as a surprise, and it's a situation they're prepared to deal with. And if they have communication difficulties, assisting them with how they're going to overcome that in the formal expert interview situation.
Yeah. The other big another big key stage in these cases, Ben, is where we issue court proceedings, and that's big for us. You know, it's a big point in the case, and it feels like a really big point to lots of our claimants as well. I think that most clients actually tend to think that this kind of it means that their case is propelling towards trial very quickly, and they start thinking about whether they're going to have to be in court, and watching all their ITV dramas and preparing for the worst. But talking seriously, how does a case kind of change after court proceedings are issued, and does this tend to impact upon claimants in a significant way?
Well, you're absolutely right that commencing court proceedings does create a change in a case. It becomes more formal once you commence court proceedings. You're involving the court formally in the case, and the court will set a timetable on the case to get you eventually to a trial, and that timetable needs to be complied with. And so there are lots of stages to get the case ready for the trial, and the claimant is going to need to help with that. So there are decisions that are going to need to be made. Now, not every claimant makes decisions on the case themselves, but they may need to contribute towards those decisions by providing information. But if they are making decisions themselves, they need to make decisions, they need to provide information, they need to give the go-ahead to their lawyers at each stage, so that to help the lawyers to comply with the time limits that they're operating under. So it does become more pressured, and the lawyers are going to have to be aware of this. And whilst they will need to assist the injured person in complying with these deadlines, there may well need to be input from the family and the rehab team around them in supporting them in making these decisions, because they are important.
Yeah, and being aware of the timetable, I suppose, Ben, that's part of our job, to make sure that everyone's clear on where the case is going. And settlement meetings and trials, I mean, we've both been to a lot of settlement meetings, relatively few trials, but those are coming to the conclusion of cases, and I don't think I've seen a claimant before coming very relaxed and chilled into settlement meetings, because it feels like a huge day, and it is. How do we help clients cope with that?
I mean, settlement meetings, you're right, the settlement meetings are a big day for a client. There's going to need to be preparation for them in knowing what to expect. The lawyer should be preparing them with thinking about what the settlement parameters might be, and the people around them need to provide them with the reassurance and support, again, to help make the decisions that are going to be required on the day. But it is only one day, at least, as opposed to a trial, which is going to be even more stressful for people, because it takes place over many days. You've got, again, the involvement of the court, so it's a more stressful environment. It's intended to be a more stressful environment as people's evidence is tested. And also, on top of that, the person who's been injured is probably going to have to be giving evidence during the course of the trial as well, which is, again, another stressful, particularly stressful point for them. And again, it's all about preparation and support for them, and recognizing what is going to be a really difficult time for them.
Yeah, it's just so useful to remind ourselves of these points, isn't it? Because I think it's so easy to get lost in the case for us and for rehab professionals, getting, thinking about treatment plans and all sorts of stuff going on. It's sometimes just really useful to remember from a client's point of view, what's going on.
Absolutely. It's when it's your job and you're doing it day to day, dealing with the court process, it's easy to forget how stressful it is for people who've never been through it before. And this is almost certainly going to be the only time they ever go through it in their lives. And it's always needs to be at the forefront of our minds, trying to minimize that for them and recognizing the difficulty that it presents for them.
Yeah, and not only for claimants, we should say, Ben, because carers and family members and those closest to people that have sustained life-changing injuries, their world is sometimes turned upside down as well. And it can be a hugely stressful time for people who are maybe managing the litigation on behalf of the claimant, or even you know, if the claimant has capacity, is running the litigation themselves, just people supporting them. That it can often be hugely stressful for them as well. And sometimes we have, you know, work to provide support for those people in addition to the claimant, but sometimes it's tricky, isn't it, to draw the line between the amount of input and support for those people versus your client, because we owe the duty to our client.
Yes. So, I mean, we do owe the duty to our client, and that's first and foremost what we're there for. But it can be so important to a client that their friend, their family, immediate family members around them are able to cope with what's been thrown at them. And if they need input to assist them with that, then it, you know, ultimately that is going to assist the client as well, because everybody involved in the process with them is going to need to be strong, and they're going to need support in order to be able to achieve that. So if we can contribute to that directly or through the rehab process and the rehab that's put in place for people, then that is something that generally we need to be doing.
And have you found, Ben, in your experience that obviously we're claimant lawyers, but have you found that defendants or insurers are more reluctant to help with support for family members and carers than they are for claimants?
I think that nowadays, generally, insurers are much more sympathetic to family members, and they recognize the importance of trying to make sure that the people around a claimant has help if they need it. So I think generally, particularly with the larger insurers, that they are helpful in this regard, and they will deal with this because they recognize that it's part of trying to assist the claimant to make the best recovery that they can.
Yeah, which is ultimately in everyone's interests. Yeah, it's an interesting practice point, I suppose, for rehab professionals that might watch this, you know, about kind of documenting the need for support for those other people around the claimant and the reasons for that, and the impact that it might have if they are unsupported, and you know, producing kind of a clear timeline and documents. But as usual, I've gone over time because I'm just wrapped up in having a lovely conversation. So that's all we've got time for. But thank you so much, Ben.
Pleasure.
It's really nice to be reminded of those things, and it's a really important issue. So if anyone has any questions on the back of this, because I've gone over time as usual, I haven't left any time for questions, which is extremely unhelpful. So if anybody does have any questions, send them to Ben or me, and we'll come back to you as soon as we can. All right, the next episode of Stewarts Soundbites will be in 2 weeks' time, same time, 1 o'clock. So look out for the details, which will be coming your way soon. And thank you for joining us. Take care.
Thanks. Bye.
Bye.